So we're here tonight to talk about the subject of big data, and as our title implies, we have actually won environmental cases using big data and predictive coding, but to be honest with you, we have not yet won a case using predictive coding, but I'm here to tell you that I predict that we won a case using predictive coding. If you were to go out and ask a stranger on the street what big data is, you'd get a bunch of different answers and probably a lot of blank stares. And so we're going to structure this presentation tonight with me giving you an overview of big data, and some of you in the crowd, just speaking to you outside in the reception area, know quite a bit about this area already. Some of you don't, and perhaps you're going to learn something more tonight. I'm going to give you an overview. We're lucky to have Dean Costalas from Trial Graphics, who's going to really dig down a little bit on the subject of predictive coding, which is this hot topic that everybody is interested in. Aaron Poplar is going to talk to you about its application in environmental cases, and then Mark Jackson is going to talk about what the future holds in terms of big data, predictive analytics, etc. So, what is big data? Well, it's really a sea change, and it's interesting to talk for a moment about what it is not. We in the last century have used an approach involving random sampling to test hypotheses, to arrive at truths, but we have used small data sets in doing so. Big data, on the other hand, uses large, thousands, hundreds of thousands of terabytes of data to not get so much at the why of things, but the what of things. And that's really the big change here, is that we are a society that is changing from focusing on causality and the why of issues to the what of issues. And so we find that big data involves our lives and really envelops them. And if you woke up this morning and read the New York Times like I did, you saw that the Obama administration has revealed some new information. I'm sure Mark's going to probably want to talk about that in terms of the NSA investigations and capturing of technology. That's all big data. Examples of big data. Well, Facebook is a good example, and this is the Hastings Facebook homepage. Facebook is a great tool. Well, not all of us use it, some of us don't. And I'll bet, however, that there are a number of you in this room who have PDAs where you are logged into Facebook. And if that's not so, then perhaps on your iPad or your computer at home. And so it's a great tool for staying in touch with your family and your friends. But, there's this other side to Facebook, which is that it monitors all of your online activities, as probably many of you know. So if you're surfing the net, the terms of service say that Facebook is allowed to monitor your web searches, meaning that it takes the information and it essentially mines it and then sells it to advertisers who use that information to put advertisements onto your computer. Now, that's a kind of a nefarious example of big data. Another example that's not so nefarious is astronomy. And just to give you a sense of where we're moving in our society, in 2000, the Large Array Telescope in New Mexico started to collect information on the universe, and within a few weeks of time had amassed more information than had ever been collected in the history of astronomy. Fast forward 7 years later, and it had collected 137 terabytes of information. In 2016, the Large Synoptic Sky Survey in Chile is going to be able to collect that amount of information in a couple of days. So you have a sense that things are accelerating. I can't say that we know how exactly, but that we're using huge amounts of data to create correlations of information. Another example is genetic sequencing, very interesting. In 2003, the human genome was sequenced. It took about 10 years to do. On Friday of last week, I ordered for $100 a human genome sequencing kit. And on Friday of this week, I anticipate getting in the mail the results of my entire chromosomal makeup. So I hope there are no members of the healthcare insurance business in the crowd. YouTube. Well, we're talking about Big Data Web 2.0. YouTube uploads a video every second, and we have applications which are capable, like Google, for instance, of uploading 10 million photographs per hour, or 3 billion likes per day. And so we have these computer programs that are amassing huge amounts of data. So this needs to be put into context, because when I throw these numbers at you, it sort of just sounds like a jumble of numbers. Look at it this way. In 2007, there were approximately 347 exabytes of data on the Earth. That consisted of digital data and analog data. 25% of that data in 2007 was digital data. You fast forward a few years, and what you have is that there's the reverse. Now you have 7% of that information being analog data, 93% of that information being digital data. And as of now, some people say that only 2% of the information in the world is analog data. The rest of it is digital data. So that gives you a sense of how quickly we're moving in this direction of amassing huge quantities of data, and how people are mining it, creating correlations between the points. So if we were to take this information and we were to print it all out, which I guess somebody had the idea of doing recently in Mexico, much to the consternation of a number of people who shut the idea down, you would be able to surround the Earth 52 times in this information. If you were able to put it on CD-ROMs, although who uses CD-ROMs today, it would reach the moon 3 times in 3 separate files. So that gives you a sense of the amount of data that we're talking about. What is the impact of this on the judicial system? Well, we as lawyers use causation as the cornerstone of our profession. But that's not what predictive coding, predictive analytics is all about. Big data is about correlations, and so we need to start thinking as lawyers about how evidence is going to be introduced at trial that is designed not so much to give us insight into why things happen, but what happened. And I think some people would argue that we already have some laws on the books that are particularly useful for the application of big data and predictive analytics. Environmental law, I think, is one of those areas. And perhaps CERCLA, which is a strict liability statute, and really focuses on the what of what happened, instead of so much the why, is perhaps a good example of where big data, predictive analytics, has particular usefulness. And Mark is going to talk a little bit more about that when we get into it. So we have judges now who are actually requiring the use of predictive coding, and so it's definitely going to impact the judicial system. So I'm going to just step back and tell you in general what predictive coding is, turning to that subject, which is a specific subset of predictive analytics and big data. And then we're going to have Dean Costales come up and give us some more detail about exactly how it works. And so essentially predictive coding is the process by which you take a mass of documents, and there's debate as to how much is appropriate. I keep hearing the term 50 gigabytes and up, terabyte and up, but in essence you take a group of documents, you go through a random sample of those documents called a seed set, and you mark them relevant and not relevant. And then the artificial or augmented intelligence takes over and goes through the rest of the documents and reaches out for those that are like those that you designated as relevant. And you go through the process again until you have no more relevant documents. And that is a very sort of general, crude description of how predictive coding works. And now Dean is going to give you the specifics.
Thank you, Noel. So I'm actually going to jump straight into what predictive coding is, and just giving you a background related to it. Predictive coding, coming from my point of view and vantage point, working with law firms as well as different clients. So what is predictive coding? Kind of the topic for today. Well, predictive coding is the electronic coding, organization, and prioritization of entire sets of electronic stored data, the ESI, the items, according to their relation to discovery responsiveness, privilege, and designated issues before and during the legal discovery process. And this is where the lawyers come in. The lawyers have to decide that. So we still need the lawyers to figure out what that criteria is. So the technology is being adopted by various courts, usually progressive courts there, and we'll talk about that when we talk about the legal precedent era, and we'll talk about that. The attraction to predictive coding is that technically, or theoretically, it can reduce the review time for large amounts of documents, usually between 85 to 95%. And this is all using the technology and not people. So that's where the attractiveness comes from. We are currently still trying to figure out and develop what that range, that ideal range would be, but we're looking at very large data sets, usually in size of 25,000 to probably millions of documents. We've seen this being successful when you're talking about like second requests, when you have lots of documents, talking about gigs, if not terabytes of data, and a small amount of time. In terms of the environmental context, this is probably great when you have lots of data for an environmental litigation, and then probably for unstructured data sets, photos, videos, email, obviously, and related correspondence. So if we can go to the next slide. One more. There you go. So what I want to talk about right now is how predictive coding is being applied today, 2013. And what maybe peer law firms are using, maybe even clients are using predictive coding. So in the legal industry itself, so law firms, and I won't mention any names, I'll tell you maybe on the side, some law firms are using predictive coding, and they're slowly, and I stress slowly, integrating it into a law firm's overall discovery structure. So there are a few, as you may know, cutting-edge firms who are going to throw themselves and really glom onto the technology. Most firms are very conservative, and they're going to take it very slowly and kind of work with it until they're comfortable. So currently the predictive coding is being used to prioritize documents, eliminate irrelevant documents, QC and QA human review, so the managed review, the contract attorneys, and then supplementing tried and true data culling methods. So that would be keyword searching, date range filtering, as well as file extension grouping and related elimination. So they're using that as a supplement. So they're not taking the full advantage of it because they're still very cautious. Law firms are very cautious. So they are doing a lot of small pilot projects just to make sure that they're comfortable with the technology. The only times where we've seen accelerated use of predictive coding, again, is when you have lots of data, probably terabytes of data, and you have a time crunch. Again, that's usually with a second request. So there's articles out there right now that there's one firm, that I won't mention, who's been successful for it, but from my understanding, from what I've talked to other people with, they're the only firm who's actually successfully used it.
What do you define as success?
Success in that the court has approved using it, and they show the statistics related to it, and they're finding the right results for it. So I mean, success is not either beholder, and it's really going to be related to that law firm strategy, that legal team strategy. What I'd like to also say, what's the counterpoint to this, is that although firms are very slow to accept this new technology, on the other hand, my brethren, in terms of the consulting and the vendors, they're really pushing it as the next big thing, kind of the second coming of technology. So they're really pushing it, and you see a lot of these glitzy advertisements of technology-assisted review, predictive coding. So where does that leave us? Well, for a firm or a practitioner, to be successful in predictive analytics, predictive coding, you have to be comfortable with the technology, because it's going to be part of your legal strategy. So you have to fundamentally understand what's happening in this black box, for lack of a better term, and then guess what? You have to explain to your client who's paying the bills. That's going to be the challenge. But I do think in the next several years, once we have this equilibrium, when the technology is more acceptable, when it's going to be more cost effective, and the legal profession comes to that level, it will all balance it out, and then predictive coding will be used as commonplace as keyword searching and date filtering. Next slide, please. So, where does it leave us, especially for law firms and budgetary considerations? I think right now, any law firm worth their salt has to start considering how they're going to utilize this, if at all. And if that's going to be the case, law firms need to proactively determine how to build this. Run kind of this, the cost recovery, trying to figure out how you're going to, one, convince a client to use it, then two, how to build that back. The key consideration in terms of that budget exercise, if you will, is that how do you staff a legal team when the traditional value proposition is based on layers? Meaning that traditionally when you deal with big data right now, you're going to have layers of people to review the data. So you have contract review attorneys, first year, second years, and then it goes up to middle level associates who might do a priv review, then you have experts, then counsel and high-end partners who are relevant and focused on that subject matter. The beauty, or the horror, depending on who you talk to, of predictive coding is that you eliminate all that lower tier, because technically a machine's doing all that work in terms of figuring out relevancy, the key issues. Then you would probably need just experts to do that. So maybe technically if you would do a second request, the traditional number of people that you would probably use was maybe 100 people. Honestly, if you use predictive coding correctly, you may only need 5. So how do you change that traditional way of staffing to something so new and modern, because you're having artificial intelligence do the heavy lifting? So what makes more sense? Do you bring this in-house where you have to have a heavy resource output and setup, or do you have to subvend this out or outsource this out to someone who does this for a living? That's another issue. And this has been a current issue just in a few years ago, if you compared with a lot of law firms trying to figure out, does it make sense to bring in a hosted review tool? So you see a lot of these big firms spend lots of money, millions of dollars, bringing in a hosted review tool. And are they sharing in those success? I will say they're not, but that's a different discussion. So once you figure these core infrastructures out, budgets, the resources, and everything related to that, again, you still have to sell this to your client. And more likely than not, you're going to sell it based on that cost savings. Okay, so kind of the million dollar question, literally, is when do you use or when do you not use predictive coding? Well, again, currently any legal technology is really under the purview of the legal team, because it's under that legal strategy. So the legal team must make a determination based on the case and related objectives. So if that's environmental, if that's an MDL, if that's an international arbitration, you, as the attorneys, you have that legal strategy, and you have to understand and see if the predictive coding makes sense to use it. So in terms of that decision to use predictive coding, what I've seen clients do is that they look at time, they look at budget, they obviously look at subject matter, because not all subject matters make sense to use this, previous experience with the technology or new technology. What my favorite is client guidance, because there's some clients who are pro-technology, they'll make you use it. Legal precedent, obviously, and then just the overall feel of the project. I tell people, just trust your gut about if this feels right to use. Yes?
I was just wondering if legal malpractice insurers have had any input on whether firms use predictive coding.
You know, that's a very good question. I haven't heard anything yet, but I do foresee that's going to be an issue, because it does go to how you practice law. And it will go to malpractice. I won't speak to the law per se, but I know there has been cases out there about malpractice in terms of how people run their reviews. I think there's a few cases on the books where they ruled against a certain firm where they it was legal malpractice because they didn't have due diligence in terms of having a good QC, and they let a lot of the privileged documents go through. So I do think there's going to be a burgeoning issue with like malpractice. Because it goes to malpractice, it goes to legal strategy if you use this. And that's why people are very cautious in using it, because it's so new. Quickly, I do want to say that I've had numerous experiences. So in my last firm, when I worked with a firm, I had just quickly as a war story, I had a legal team use predictive coding. And this case was a pharma antitrust case. And we used predictive coding because the client was heavily invested in it. They had a case where they used it very successfully. And when I worked with the legal team on this, my gut was telling me, and I knew their searchers, and they were experts in the antitrust field. We had pharma experts. I told them, based on what I see, the predictive coding is not going to help you at all. It's not going to help you because you kind of know, because we had all the experts in antitrust. We had pharma people on call. I saw their search terms. They were hitting what they wanted to hit. But because we had client guidance to say, please use legal coding, we'll pay, it's not a big deal. We did. 1 month into it and X numbers of dollars into it, guess what happened? There was no change in results. It was not, they didn't find any value from it. So it was a live and learn. Thankfully the client was on board. We didn't push it, but it didn't come to fruition for predictive coding. Again, and this is kind of a good segue, in terms of the baseline for any legal technology that you're going to use, and let's go to this malpractice, what I've seen is that, and talked to with some of my clients, that they're saying that any technology or any legal strategy, they say that they will use it if they can defend that legal strategy to the court, or if there's a malpractice suit. So that's kind of a good baseline if you're going to do that. Can you defend this in court? And heaven forbid you get sued, can you defend that? So, I mean, that's kind of a good gut check for that. So what are the challenges? So the challenges for predictive coding, or any new technology, because predictive coding is what's hot right now, and it will be hot for the next handful of years, but something else is going to come into our radar. Well, so what are the new challenges for this new technology, predictive coding? Well, I think the challenges are in the execution. The theoretics and the academics are there, but it's the execution where a lot of firms fail in this. So right now the approach is still very new. This predictive coding is so new. And no one wants to be an early adopter. No one wants to be the guinea pig. I haven't found, from all the firms that I've worked with the exception of a firm that no longer exists. And we know who that is, because they were very, I'll say, quote unquote, progressive. No one wants to be that early adopter, and no one wants to be that guinea pig. So that's going to be very interesting to kind of get over the hump. And predictive coding is currently considered a black box technology, meaning that you put documents in and the goal is, and miraculously, you're going to get the related documents out. So, and then also, and this is one of the key fears, how do you quell the fear of an inadvertent production using predictive coding that may lead to privilege waiver? Because you're trusting that the algorithms are right, the content analytics are right. So if you're not very comfortable with the technology, how do you sleep at night with that? Yes?
Does this lead to a battle of experts in predictive,
Oh, definitely.
Do you have an expert that goes, no, we use the right criteria?
Yeah, definitely. It goes to who's the expert, and
or
then
hiding stuff or something.
and that's, you hit the nail on the head. It goes to the experts, and then does that also mean that do you need to require that the legal counsel, so an attorney, do they need to be that expert in that algorithm or whatnot, or do you hire a hired gun or the person for that? So there's different ways where you hear that, because I've seen in the industry with the law firms I work with, they want someone like an attorney, and it's usually going to be a middle associate who has the time to learn this, to be kind of that discovery / predictive coding expert, because they're going to do it so much based on repetition. So that's another challenge. How do you staff that internally? Lastly, I do think a law firm does have to pick a side on this predictive coding. So if you're going to pick a side, what's going to make the difference is that it's going to be all about planning, and you're going to have to figure out a strategy based on creating new revenue models, because the old way's not going to cut it in terms of like an hourly rate, and then obviously selling the clients on using it, figuring out what technologies there are to use, because there's a variety of predictive coding technology, and they're all proprietary. Obviously solidifying the traditional methods to do reviews, and then determining whether to bring this in-house and spend all that capital in-house, or do you outsource it, or do you do a hybrid approach? So I'd like to bring up Erin to talk about the law.
Thank you, Dean. I get the dry stuff that I'll try not to make so dry. So my grandfather, who is turning 90 at the end of August, for most of the years of his life, was a civil engineer, and he worked building bridges. He had many, many stories to tell about the challenges and joys of bridge building. And to this day, you don't want to ask him, unless you have a lot of time, what his feelings are on the current Bay Bridge retrofits. You just don't want to go there. But one thing that really sticks with me that he told me was the simple function of a bridge, which is to build a span between the gap that exists between where we are and the goal of where we want to reach. In many ways, predictive coding and environmental litigation can serve as just such a span. In environmental litigation, you often start, as Noel discussed and Dean a bit, with a large volume of documents and data. You're often also under a time-sensitive crunch to get from that volume of documents to the other side, which is a comprehensive and effective resolution of the matter. Predictive analytics is a great candidate to use as a tool in your discovery toolbox in environmental litigation, because these cases typically involve many parties and many claims. There's often a regulatory component with its own data set and relevant documents, and the what that we care about in cases like CERCLA spans over many years, sometimes decades of time, all of which results in a lot of information to process. Additionally, because, as Noel also touched on, in a long litigation battle, often in environmental law, there's not a clear winner. So there's a premium placed on early settlement. Well, how do you get from this large cache of information to understanding the value of your case? Predictive coding can be an excellent tool to do just that, filtering for relevant and case-critical material. Another reason, a major reason in fact, that environmental litigation is a good candidate for the use of predictive coding is it often involves federal statutes, meaning these cases are litigated in federal court. That's significant and matters because federal courts have a particular sophistication with regard to e-discovery, as well as an increasing expectation that technological tools like predictive coding be utilized. E-discovery is nothing new in federal courts. It was 2006 when the federal rules of civil procedure were amended in order to particularly call for the discovery of electronically stored information, or EIS. ESI, excuse me. In federal courts, there is a very strong expectation that parties fully comply with ESI requirements, as well as utilize technical tools available to them in order to reduce the cost and burden of ESI discovery. Further, federal courts tend to be particularly intolerant of parties that use under-inclusive or informal approaches to ESI discovery, and the consequences can be quite dire. Dean touched on this a bit, including waiver of the privilege. For example, in a well-publicized case in 2008, Victor Stanley versus Creative Piping, a magistrate judge found that the defendant's reliance on an insufficient keyword search resulted in the waiver of an attorney-client and work product privilege. Because the court found that this keyword search was not a reasonable precaution against the inadvertent disclosure of privileged material. Similarly, in 2010, in the Mount Howley decision, the court opened up by generally instructing practitioners that given the ballooning state of electronically stored information, litigants and practitioners generally needed to start sampling in the document review process earlier on, and it's no longer sufficient to wait until all documents have been received. Applying that general rule to the facts of this case, the court, similar to that in Victor Stanley, found that because the plaintiffs there had failed to implement sufficient quality control sampling, they too had waived the privilege on all documents that had been voluntarily, albeit inadvertently, disclosed. Given what may be at stake if ESI is inadvertently disclosed, waiver of a privilege, it becomes clear why tools like predictive coding are so essential to not only identify materials that are relevant, but also materials that are protected. Federal courts increasingly have approved the use of predictive coding for just such a tool. The seminal case on this issue is from 2012, De Silva Moore versus Publix Group. There, Judge Peck of the Southern District of New York was the first to consider and approve the use of predictive coding. He's widely felt to have opened the door for its increased use. At issue in the De Silva case were 3 million emails that had to be reviewed and filtered. The parties agreed, yes, we want to use predictive coding, but they could not agree on how to implement it. The parties further agreed that it would be appropriate to begin with a sampling seed set of 7,000 emails. Defendant was also willing to allow plaintiff to see the results of that entire seed set, which was significant because it included even ESI that was deemed to be non-responsive. Judge Peck, in light of all these criteria, determined that yes, predictive coding is appropriate for use, and I approve this plan. The criteria specifically that he found to satisfy the use of predictive coding in the De Silva case was the parties' agreement, they both wanted it. There was a vast amount of ESI to be reviewed. Computer-assisted review was superior to other alternatives. There was need for cost effectiveness, and the process the defendant proposed enabled complete transparency. Another decision from the Southern District of New York shortly thereafter confirmed that De Silva was not just a fluke, and predictive coding was going to be approved under the right circumstances by courts. In that case, National Day Labor Organization versus ICE, the court denied in part ICE's motion for summary judgment. It found that its search had unreasonably excluded certain records for custodians of custodian of records. The court then required ICE to conduct a new search for these specific records that have been excluded, and demanded that ICE meet with the other side and develop mutually acceptable search terms and methodologies to conduct this search. However, the National Day Labor Court did draw a line in the sand. It was not willing to go so far as to make a ruling on the efficacy of the search terms the parties ultimately agreed to, or that they be vetted by the court, saying instead, for lawyers and judges to dare opine that a certain search term or terms would be more likely to produce information than the terms that were used is truly to go where angels fear to tread. Subsequent case law has clarified that absent all the factors that were present in De Silva, the courts are still willing to approve the use of predictive coding. For example, in the Robcast Inc. versus Apple case, also from 2012, the court determined that transparency, complete transparency that is, was not required provided that the parties agreed to the use of predictive coding. In the Gordon versus Kalita Health case from 2013, the court determined that a sample seed set was not a prerequisite for the use of predictive coding, also because the parties had agreed to its use. In 2013, the door that Judge Peck opened seems to be opening wider, and courts are taking bold steps through it, approving or at least endorsing the use of predictive coding in cases where it has not even been at issue. For example, in the 2013 case, EORHB, the court approved the use of predictive coding, although neither party had expressly requested it. Similarly, in another 2013 case, Chevron versus Dozinger, on his own initiative, the judge cited the availability of predictive coding to reject arguments that a subpoena was unduly burdensome. The specific facts of that case were a non-party law firm that had been subpoenaed argued the cost of producing documents in response to the subpoena was going to be overwhelming given the infirm attorney time and contract attorney time. The court said, nope, this is an exaggeration of costs. Predictive coding is available to drastically limit your production and quicken your review time. This emerging legal landscape that I've just discussed really begs the question. With federal courts increasing expectations that parties at minimum consider predictive coding as part of their e-discovery plan, should we expect that this is going to be the new norm? And if it is in fact the new norm, can attorneys cooperate? Because what the case law has instructed us thus far is predictive coding is far more likely to be approved and to be implemented successfully where attorneys first and foremost agree to its use. On a larger scale, I suggest the possibility that predictive coding, given the potential mutual benefit to both parties, which both Noel and Dean discussed, to contain costs and to identify case-critical materials early on, could serve as an unintended bridge across a legal system, the very nature of which makes it difficult for attorneys to cooperate and work efficiently together. In other words, a span between the gap that exists and where we are and the goal of where we'd like to be. With that, I turn it over to Mark, who will conclude our remarks for today.
Thank you so much, Aaron, for bringing us up to date on those cases. My job for this presentation, as I see it, is to, as much as I can, try to scare the heck out of you. And I was thinking if this presentation were a movie, I would be played by Jeff Goldblum. I'd start talking about the future and how we're all going to die. So I'll try not to... I'll try to meet those expectations. So I really want to talk about three things, and this is all oriented toward the future. And the first is, I want to talk about what's coming for the future in real general terms. And then I'd like to give a sneak peek into some changes that are affecting how we look at the environment and environmental law in particular. And then finally, I want to give you what I think are some important, practical tips for how to move forward as legal practitioners. So, let me, I guess, tell a quick story. I was at the Sedona conference gathering in Philadelphia about 2 years ago, and there was a challenge to the audience made up of very well-versed e-discovery practitioners. What is the largest data set that you've dealt with in your career? And we started at a pretty small number, and we went around the room, everyone keeping their hands up, until we were left with one woman who still had her hand up when we got to the number of 5 terabytes that she had to deal with on a case, which I think is a large amount of data by anybody's standard. But I have to ask, has anyone dealt with a case that had more data than 5 terabytes? Yeah, that's a lot of data. I think if we asked that same group, we'd probably get a similar answer, maybe slightly more. But I was thinking, what is the biggest e-discovery case that anyone's ever heard of, that we've ever had? And I think it was handled by this guy. I'm going to talk a little bit more about the effect of the recent NSA disclosures, because I think it actually has a lot to do with what we're talking about today. Needless to say, the disclosures that have been made have revealed that the U.S. government has been capturing, collecting, storing, and analyzing huge sums of information about not only foreign individuals, but U.S. citizens, storing that data for a period of time and using highly sophisticated tools to analyze that data and make decisions about it. Another NSA whistleblower from a few years ago, William Binney, he said that there were 20 million transactions just between U.S. citizens that the NSA had collected, and that was just involving email and phone records. And now we know that we're talking about a lot more than just those things. We're talking about video data and chat data and a whole lot more. So when we're talking big data, that's sort of, I think, the high watermark. So I want to talk about just a few more changes, a number of changes that I see coming in the future, and the first really is the continued growth of data. And this is somewhat of an obvious point, but I want to mention it just the same. So here we have at the bottom the growth of the economy, which I wish was a little better than that. But the amount of data that we have stored is growing at a rate 4 times the rate of growth of the economy, and our computing power is growing 9 times faster than the economy. And that's just going to continue to grow. And along those lines, we've been talking about predictive coding and what it can do today. But here's the thing. Predictive coding is just going to get better. And computers are just going to become more powerful. And I'm sorry to have to admit, as a human being, we're probably not going to get that much better over the near future. Because we have evolution, and that's pretty slow. So, it's all changing fast. So somewhat of an obvious point, but worth making, I think. So the other thing, and this is maybe also somewhat obvious, but for whatever reasons, people continue to share huge amounts of personal data through social media and other activities through the internet. And in fact, I was mentioning this topic to my wife, and she was telling me about a friend on Facebook who thought it would be appropriate to share pictures from her recent sinus surgery. Oh. I thought, that's what people like to share. Totally appropriate. Similar to this, for my birthday, my mom actually got me one of these Nike Fuel Band bracelets. I don't know if you all know what this is. There's a similar product made by Java. Essentially, this is a pretty powerful little computer that has an accelerometer built in, and it can derive information about your movement, how many steps you take, simple things like that. But the jawbone can even calculate things about your sleep patterns and tell you when you ought to wake up in the morning, things like that. But here's the kicker. You can upload this stuff onto Facebook and Twitter and compete with your friends to see who has the best data. And of course there's Google Glass. There's apparently a somewhat derogatory term in San Francisco that I can't repeat, but it starts by omitting the first few letters. I haven't seen anyone walking around with these yet, but they're out there. Obviously, these are things that can capture video and post things to the web in real time. It's a lot of potentially very personal information, and people are connected to the internet with those devices. The short of this is we're all becoming cyborgs, whether we like it or not. And unless there is a massive shift away from this trend, we're all going to become part human and part machine. And all of that machine data is going to be easily shared and easily stored and easily collected and easily analyzed by lawyers. So what else is down the road? So, oh, by the way, if you think there's any limits to the extent to which humans are willing to capture data about themselves, I recommend this article from The Atlantic, which I think was from earlier this year. It's about Larry Smarr, who tried to capture as much information about himself, about his body, everything from normal sort of vital signs you would get at the doctor's office to imaging of his body and even tissue specimens and feeding that all into a database to try to see patterns and maximize his physiology. Well, you can imagine a world where this isn't just some extraordinary person doing that, but we all have access to that, and we're all doing that as part of a health program the way we might go to a doctor today for a checkup. So I want to turn to what I think is actually a very big issue. And for a long time, I think people thought that all of this data that we're sharing through commerce, on the internet, all of this information we're sharing through social media, boy, wouldn't it be horrible if the government started collecting all of that and using it for their own purposes? And now we know that at least in part, that's what has been happening. And as of this morning, in fact, there was a new article in The Guardian who's been following the story most closely and revealed yet a new program called X Keystroke, which essentially allows an agent or even a contractor for the NSA access to all user activity taking place on the internet. Not just metadata, but content, and all content. And that's fairly well documented in the information disclosed today. So now we know that that's what is happening. Now, what does that mean for the future? Well, on one hand, we could continue down this road of increased data growing in the world and governments continuing to collect and use that information. But many people are wondering whether these disclosures are so explosive that, in fact, people are going to react to this and demand some change. And I guess I'm skeptical of that, because the internet works so nicely. People don't want to mess it up. On the other hand, isn't it intolerable to have people monitoring what you do, if in fact that's the case for you personally? But, it's beyond just whether there's going to be a public backlash or people marching in the streets about this, because there are in fact laws on the books in other countries, if not this country, but certainly in the European Union. There's things called data protection authorities who have the authority to actually enforce the law and fine companies who breach data laws and who disclose and use and collect personal data. And one has to wonder, what is going to happen if U.S. internet companies feel obliged to follow the demands of the national security state here, but also follow the laws in Europe, which demand greater privacy protection? And what is going to happen if people refuse to give their data to U.S. companies in favor of other companies, other places in the world who can reassure them that their data will be safe? What I'm trying to say is that the internet as we know it could change, and it could change rather rapidly, depending on which way the tide flows. And that I will not predict. I want to just shift gears now and mention a few things changing in the realm of the environment and environmental law. I want to mention a couple of things, and Angela Sue, who's the project director for the Environmental Performance Index, she's lamented that environmental groups haven't really begun to use big data, how they might be able to, but she gave a few examples, and I want to mention them here. One is this platform called Danger Map, which made its debut in China, and it's essentially a crowdsourced pollution map so that people can make decisions about where they want to go and where they want to live. But that is now an open source platform that NGOs can use anywhere in the world. Another example, the World Resource Institute and the Center for Global Development have been using tools to aggregate data regarding everything from carbon emissions to deforestation, and using that data to make decisions. Similarly, the NEON, or the National Ecological Observation Network, aims, and this is in cooperation with the National Science Foundation, aims to be collecting data from citizen scientists all the way up to not learning how to fly their planes properly, but even more important than that, they weren't remembering when to fly their planes. And so there's a lesson there for us all. I propose that no matter what changes are coming in terms of technology, as litigators, it's always going to be important to know how to fly your plane, to take depositions well, to interview witnesses, to know that it's more appropriate to go interview a witness rather than review documents, to be able to write motions, to be able to try cases, to do all of these fundamental skills that we're trained to do, and not be distracted by the glowing lights on the instrument panel, but to continue flying our aircraft. And so, when you leave today, I hope that's one thing you will remember. I want to thank you so much for coming. It's really been a pleasure presenting to you all. And I want to thank Jen Rupert and Violet Evangelista and Lisa Mule with our firm who've been instrumental in putting this all together. And of course, thank you all for coming today. It's really been a pleasure. Thank you.
Question.
Yes?
Why does the industry use such a user-unfriendly term as predictive coding? I notice even in Recomind's issued patent, they refer to the older term predictive tagging, and Erin, in her speech, used predictive analytics, which are far more user-friendly and describe what the process is rather than predictive coding. As soon as you put coding in there, you scare everybody off.
Well, that's a good question. I think it just goes down to marketing, because I think if you look at the history of discovery, when we were talking about coding, there was objective and subjective coding, and you had to manually do it. So it's kind of a carryover. It's similar in vein to when people still talk about printing blowbacks. Blowbacks, it's not a relevant term, but people still use it, saying, I need a blowback of, you know, these documents. I think it's just bad marketing, to be quite honest. I think if Recommend was worth their salt, I know people I think they should market it to something a little bit more user-friendly. And you have a point that I think it's just marketing and just using a lot of the archaic terminology and carrying it over.
It's
Because
not really archaic, in fact, tagging, even most people here probably know what hashtags are and tagging documents are, but, predictive coding, I mean, it's like, I don't wanna touch it, I'm gonna leave it to the expert.
yeah, I don't know. I mean, we would have to. Recommend was the first one to coin that, and as you correctly said, in terms of that patent. So I don't know why they chose that versus, you know, analytics or review analytics or something that's a little bit more palatable.
But even
That's
in their
their
patent, they used, predictive tagging.
Yeah, and well, the thing is with well, I won't get in an argument with that. With tagging, depending on the review tool, people don't tag though, in terms of the review mechanism. Some are automatically issue coded or issue aligned or something. So I think, for me, based on who I've talked to and what I've seen, I think it's just a carryover of some terms based on the tradition.
Well, I beg to differ.
Yes.
So I have a question just about the basic mechanics of predictive coding. And so I'm involved in a very large case with 100 years of contamination, 8 very large parties with very large law firms involved. Not one has mentioned predictive coding. And we produced over 1 million pages of documents so far. And we're still in the early stages. But I'm curious about how you go about the actual mechanics of developing your seed set, and where do you go from there? So what, in the actual implementation, how does that work?
Well, it varies depending on the predictive coding software you're using. So Recommend is one of them. Relativity has something built in. Clearwell has something. So it really depends on what software you choose or what vendor consulting firm. So there's a certain methodology about what Noel said in terms of you do have to do some sort of early case assessment, or you have an idea of the documents that you want that are relevant, irrelevant, and that serves as your seed set. And then based on the statistical analysis, they say you need X number of documents that you have to find in order to match based on the percentage for it. Then depending on the amount of data you have, it can take days, if not weeks, to process for that. So it's not, the one thing about predictive coding, depending on the size, it's not instantaneous. That's one thing I could tell people. People are not realizing that it's just not, well, here's 70 documents and magically they'll pop out in 30 seconds. The example that I mentioned, it took a month for them to really get a grasp on what was going to come out. I mean, they were doing it every week, but there's a lot of time devoted for that. And you also want the expert in that field, albeit an actual expert and or a legal attorney to really kind of make those decisions, because you have to make a call on certain documents that it's coming through. So what it does is that you put the seed set in, something comes out and someone has to review it to say, okay, we're on track, this is not on track. Then it keeps repeating the process till you get some sort of statistical regression to make sense that we can then apply this intelligence or this set to the rest of the data. So it's really, it's interesting for that, but I think that it's where the execution is going to come to head, because you need people to spend the time. It's still not fully automated. We still need attorneys for it, but then how many attorneys do you really need, and how many attorneys do you devote to that?
I'm thinking of Mark's comments, I'd still like to be the pilot flying my plane, and selecting the seed set, and
Oh, of
just
course.
trying to figure out how you would best do that in order to gather the relevant and
Definitely. Well, and the attorneys are the ones who do that. I think you do like an initial step to see if we're on the right track, but then ultimately it is up to the attorneys to say, okay, this is what we're looking for. These are, based on what we picked out, here's some handful of relevant documents, and these are irrelevant. So it's, the attorneys are still driving it, but I think a lot of people, especially the people who are selling it, feel that this is like the silver bullet, where magically you push something in and you get all relevant documents, and you don't have to worry about privilege, and that's the biggest issue, especially with like PRIT, because the fear is based on all the surveys is that you can still use this, but do you have a good protocol and methodology to address any privilege waiver? because you're taking full faith that the computer, that algorithm's gonna catch it, and more likely than not, it's not.
You know, Sandy, an interesting spin-off to your case is one that we have where the site is has about 117 years worth of operations also, multiple large firms, and what sort of drove this presentation was that I went to a town group breakfast, a roundtable breakfast, that Mark had actually gotten me invited to, and the subject came up, and I came back to my firm, and I said to one of my partners, you know, we're gonna think about using predictive coding, and he said, we'll never use predictive coding in environmental cases. And I said, you want to bet? And then the following Monday, we had a meeting with opposing counsel to meet with her on the side, and I asked, you know, how the parties were going to deal with the large volume of BSI. And one of the large firms on the other side immediately said, oh, we're using predictive coding. Whereupon I reached across the table and went like this to my partner, pay up. So, you know, it's interesting, really, I think that this is a very topical subject, and, you know, I will say I have clients here who are going to call me tomorrow and say to me, hey, Noel, on that case, should we be using predictive coding? You know, I think it's an open question, we need to have a discussion.
Non-privileged, by the way, one of the rules in federal court anyway is 502, Federal Rule of Evidence 502D, where you can reach an agreement concerning non-waiver on large electronic data sets.
Yeah, that is one of the offsets of the messiness of predictive coding and predictive analytics is that you have clawback agreements that protect people. But you know, as you and I both know, firms are often not particularly cooperative in honoring those clawback agreements. And if they want to give somebody a hard time about not honoring the letter of their compliance with it, you know, it can be a problem. But, yeah, thank you. Well, Sandy, you know the federal rules of procedure back and forth inside and out.
You can only wait too much for that.
Yeah, well, I'd like to make just two points in response to that. I think it's really exciting that technology has the potential for, to borrow Aaron's metaphor, to bridge the connection between the senior-most attorneys on a team and the documents, the foundation for the case. Because often there's that separation where you can't, as a person high up in the hierarchy, be down in the battlefield as much as you might want to. But technology promises to bring you closer. And then the second thing, sort of a caution, and this is my personal opinion, but I think this is all so new that I would not recommend using predictive coding in any case unless you have a written agreement of all other counsel in the case, because the defensibility is still an open question. Unless perhaps you're in front of Judge Clark. Yes?
So, from what I'm understanding of the presentations, a lot of the uses for predictive coding is in document production. Do any firms use predictive coding to analyze documents that have been produced to them? And when you receive a large amount of documents, and yeah, every attorney's going to want to go through every single document to find that smoking gun, but do you guys anticipate or have any experience with firms that have used it on the offensive side?
First of all, what firm are you? The answer is yes, and we are using a product that enables us to review documents using predictive coding just for internal review.
Yes.
I just wanted to know that all of the cases that were listed as references for predictive coding were all on the East Coast. None of them were based in the Northern District or the Mississippi District. So I was wondering if any of you have comments to make possibly the destruction. You know, Silicon Valley companies are going to use it against one another, or if you think it's
certain judges who are big advocates. Like if you're following e-discovery, there's a handful of judges that you always hear their names, like Judge Peck. I think there's a judge out of Texas who's very progressive. So I think they're the ones who want to set the standard, and everyone kind of falls in line, and obviously there's always precedent. Well, we'll get there sooner rather than later. So it just happens that, you know, with Judge Peck, he's the one. If you read all the EDD blogs, if you see legal tech, he's always there. So.
Yeah, and to Dean's point, Judge Peck is really, has been, even before the DeSilva case, has, you know, published a lot and spoken a lot about predictive analytics and coding. So it just so happens this case fell into his lap and began to set a precedent from there.
Well, do we have any other questions? Oh, yes, we do.
A quick question, how does the learning curve work on different source documents? If you feeded a bunch of documents from one source, it learns that.
Well,
If you have completely different types of documents.
definitely. Well, it varies per software. So you would have to kind of figure out what software. So like if you're talking about Recommind, they use more of an advanced algorithm that's also proprietary, and they would have to know that. And then there's other ones. I think the other competitors like content analyst based one, which is like a learning based one. So you would have to kind of, and this is where it gets very complicated. You then have to read what they are, and then work with that software provider and or related vendor, and really just understand that. It's very complicated in that respect. I don't even know that offhand. And every time we have to use it, I have to get a refresher and get an expert from Recommind, because they are constantly changing and evolving it. So on an attorney's end, you have to be comfortable with that whole kind of iterative process. So it really varies. If you say, if you talk to Recommind, they say they're the best, and then you talk to someone else, they say content analyst is best. And with content analysts, a lot more programs use that as
No,
a baseline.
actually what I was meaning was this, you know, the source of the document, if it's from a regulatory agency or if it's from the client.
Oh, it doesn't matter. It's whatever documents are, make sense in terms of whatever that legal strategy, what you consider responsive. Usually you'll have an idea because you already have some document sets anyway, and you know that it's hot or responsive or relevant. If you haven't done that kind of early case assessment, if you will, you can have the predictive coding or the software just run it and see what you get, and then have a gut check and gauge it from that. Then you pull against. So there's different ways you can kind of skin a cat, if you will, with predictive coding. That's why it's so exciting. And depending on what software vendor you talk to, they'll extol the virtues accordingly, or even name it differently. One vendor's calling it like technology-assisted review and not predictive coding. I think predictive coding is more generic.
Does that make you happier?
I don't know. I know enough about the vendors, software vendors, but I don't know about them.
Any more questions?
So before we all leave, we have a raffle, and if you want to participate and you haven't had a chance to give Kevin your business card, now is your chance. And then we hope that you'll stay around for a while to continue catching up.
Yeah, I did want to mention there are gift bags, and make sure that you plumb the gift bag, because at the bottom is a very nice little, what are they called? Big data instrument, otherwise known as a, thank you.
We'll do the raffle real quickly.
Oh, I thought it was just for the speakers.